right, it's Thursday. We are live. It is 7 o'clock. This is Why Libertarian. I am Matt, coming to you every Monday through Friday at 7 p.m. I got a little bit of a treat for you. We're debuting like a regular weekly segment that we're going to be doing here going forward into the future. It is called Natural Rights Talk. We're going to be discussing natural rights because, as you're going to find out from my very special guest, that not very many people understand it, namely the people that are supposed to understand the law. But so that being said, before we get into it, a reminder, like, comment, subscribe, share, hit the notification bell, retweet, get this out there. This is going to be really powerful information. Like, share this because today is kind of like our overview of it, and then each one of our successive episodes, we're going to be doing a deeper look or a deeper dive into each one of these various issues, and you're going to see it's voluminous, so we're going to have a lot of information to share, and it's going to be pretty eye-opening. So, and then a quick reminder, tomorrow night I'm live as well, and I have Martha Bueno on, and we are going to be discussing Latinos and their role within the liberty movement, both domestically and internationally. So it's going to be a good time next two nights to end out the week. So without further ado, I want to introduce my guest. This is Josiah Hinkle. How's it going, Josiah?
Hey, how's it going?
Wait, remind me and the audience where you're coming to us from.
Well, from the American Natural Rights Foundation.
Yes, and so the American Natural Rights Foundation is your baby, right? Like your organization?
Yeah, I founded it with another individual.
Awesome. And so what really kind of brought that about? What was like the inspiration for it?
Well, I guess he and I were kind of working on the research at the time. I was kind of introducing him to some historical narratives that I had kind of pieced together from some research I had done. Mm-hmm. And he ended up having to move to Oregon. And so the project just kind of stalled for a few weeks. And I happened to just hear an ad on the radio about a nonprofit and just kind of thought the idea, like, hey, you know what? That would really, allow us, because it really opened the door into what do you need to actually make the change? Because this information is out there. You know what I mean? It's available. It may not be understood by a lot of people. It may not be as comprehensively gathered, but it's certainly out there. But yeah, so with the idea of it being an organization, that just kind of led to the ability to have, high quality employees who could do research, who could verify things, and then, kind of create an educational aspect to that where they could provide education to not only, government agency, like say a police academy, but actually to, the public, to actually like K through 8 or, high school and collegiate programs. And so then on the other hand, it just, being able to go to the government and kind of lay the groundwork to, introduce what they might be seeing, what they might misunderstand or whatever the case may be. But so that when the public actually comes to use some of this research, they're not just hitting kind of a wall. Yes.
Yeah. Well, first of all, disclaimer, I am not an attorney. Josiah, you're not a licensed attorney, correct? You're a legal researcher, and this is being done for educational purposes. And one of the things that you said to me at the beginning when we just first started to talk and you reached out to me was something that was really kind of alarming. A lot of people would think that there's like this long vetting process to go from being an attorney to a judge. That's like not the case, right?
Right. So, it only takes 5 years of being a practicing attorney to qualify as to sit as a judge. And oftentimes even that's not even necessary because I can't remember the name of it, but they'll even just invite lawyers in to act as a judge for, a temporary time.
It's like giving a 19-year-old keys to a Ferrari.
It's even worse than that because when we actually get into the stuff and we start talking about courts, you're going to learn that lawyers really, well, we're not going to talk about it today, but in the future we're going to talk about, courts, and lawyers, their primary experience with courts are courts of equity and equity jurisdiction, and so the consequence is basically, they don't understand the law because they're two different beasts. So.
Yeah. Well, and I think that's also really important and we were talking right before we went live. The law is so complex that there are a series of things that, most cases or most rulings or laws are based off of. And you've made the point in the past that like a lot of those baseline things that attorneys and even judges are supposed to understand, or even police officers, they get that wrong, which means that we get garbage out the other end. Is that accurate?
Yeah. Well, it's not like there hasn't been an intentional campaign to make that the situation. But
Yeah.
yeah, you're definitely correct in how you articulated that.
Yeah. Well, so before we kind of get into, we have a lot that we're going to cover into the future here. And I want to make sure that we kind of like hit on each one of those as we go through it. And you can kind of like walk us through the write up that you've given us. But so, what compelled you to do it? Like, I mean, what from your background really got you interested in doing this? Was it a personal experience? Had you always been involved in the law? What was that like?
Well, yeah, I guess growing up poor, I grew up under the Bush regime, you might
Hmm.
say, and I kind of came
That's a good
across,
word for it.
yeah, and I came across, Zeitgeist. Not for sure if you're familiar with that work by Peter Joseph, but yeah, it kind of opened my eyes to a lot of the government corruption surrounding 9/11, and
Mhm.
from that point on, while I kind of got swindled by Obama, he said a lot of fancy words that I was like, hey, that's exactly what would make sense. And so
Yeah.
I didn't vote. I was still like 16 at the time, but I was at least, like, maybe there isn't going to be corruption for once. And then it was all corrupt, and it was so bad. And I remember by like 2012, it was just so bad. It was just like blatant and terrible. And yeah, so I've kind of, I inherited a set of law books from my grandparents, and anytime a situation would arise, and I'd be like, let's look into that, and I'd check them out. But it always just left you, powerless. Like
Yeah.
there's nothing in there that really is helpful. It never really helped, and I just kept with it, and I happened to come across some information that kind of led from one place to another, and that just kind of developed, everything you see before you. So at
Awesome.
the same time, I guess I would also mention that I saw a lot of other people utilizing some of this resource, some of this information, and a lot of them, mistaken about some of these things.
Mhm.
And just like with a little bit more of the historical research or whatever, they could have had the context that would have kind of explained or, you know, taken away some of the errors that in the end ended up getting them, fines or jail time or whatever. So my intent with this organization was just to make robust and absolutely verified and solid research first so that, nobody's led astray and nobody, ends up hurting themselves when they're just trying to assert their rights.
Yeah, I think that's fantastic. I think, and it's actually surprising to me that someone hasn't done this in the past because I guess maybe it's just the nature of law school and how lawyers are kind of churned out in the thousands. That's probably why this hasn't been, kind of more prevalent or formed that foundation. The one disclaimer I want to make to people is, and part of the reason why I think you're going in the direction that you're going is, I think a lot of people have this misconception that like someone who considers themselves a sovereign citizen or someone who's a studier of natural law, that they can just walk into a courtroom when they're charged with something and essentially cite the precedents for natural rights and natural law, and then the judge will just be like, oh well, since you said that, like there's no problem anymore. But that's not the case, is it?
Well, it's not the case in practice, no.
Yeah.
In fact, you've got a lot of even if you had malicious intent, which I totally agree there is, you just got, a bastion of ignorance. And, what that does is makes, like I said, it's like you go up with all this stuff and it's a wall that you're talking to because it doesn't mean anything to them. They don't understand it. And like you were saying before, kind of pumping out all these lawyers. Well, even talking to my couple employees that we've had, in after reviewing all the information, all the different law and stuff that we've come across, I've asked them, like, so how much of this are you familiar with? Like, and they're like, none of it. They don't teach you any of this in law school. And it makes a lot of sense because again, we'll get to it, but what they're learning is, equity. So,
yeah. All right. Well, so without further ado,
I do want to make a point just to on the disclaimer, bend and everything, that this is the research we're currently working on. So there's some of the stuff that's kind of undeniable. There's nothing really that can be argued against it. But this is a pretty good introduction to a lot of the stuff that we're looking into currently. That it looks like is what the case is, and we're actively trying to verify it all.
Awesome. Okay, so I'm gonna pull this up. So this is basically an overview, and if you can expand it, and anyone who's at home, if you can expand it, fantastic. If not, we'll make this available for you to be able to download it at some point. But so this is basically the bullet pointed list, and the one thing that you wanted to make sure to tell everyone was each one of these bullet points is essentially a compendium of law in and of itself. So just remember that. And as you go through this, I think everyone that hears this, or if they watch the recorded version, they should understand that each one of these bullet points it's not just like some sentence somewhere. I mean, it is literally pages or cases full of law that go into, this statement and the way it is, or the way you're saying that it probably should be interpreted. So, all right, so we're starting with hierarchy of law. So kind of tell me a little bit about the hierarchy of law and kind of the overview there.
Should I just go through it?
Yeah, go for it. Go for it.
All right, well, yeah, so we call it the hierarchy of law, but we find it's a pretty exciting thing because it's something that makes our job a lot easier. A lot of good people are out there right now. They recognize something's wrong. They can see some issues. They're doing what they can to fight the good fight and make changes where they can. And when you understand the hierarchy of law, you'll see that actually a lot of these battles are even unnecessary. They're already won, and those efforts could be redirected to things that are a little more effective, and such as jury nullification, which is what I want to talk about after this. So, anyways, I guess. Just in a little nutshell, law, there's an underlying hierarchy of authority that determines the force of any law. So in the Western political philosophy, or, political legal philosophy, you've got God's laws, and that's at the top of the hierarchy. And that just translates essentially to natural law, which includes things like gravity, believe it or not. But it also includes things like the Christian morality. For example, which encompass common moral principles, and I've got a couple things on there like patience, good faith, and honor and dishonor. And so after the natural laws, you've got man existing in the state of nature with other men, and man is independent of all laws, and except those prescribed by nature. He's not bound by any institutions formed by his fellow men without his consent. So you'd contrast this with a civil society, which acts in a political capacity as a body politic. So the next thing would be the body politic, and in our specific instance, that's a republic where the sovereignty resides in the people. And in this and the people actually means members of the civil society. So the sovereignty resides in the people, and it resides in them individually rather than collectively, which we've kind of been led to believe. And so what do we mean by the sovereign? We're just saying it is a term for the highest authority in the body politic. So after that, you've got the Constitution, and a Constitution is legislation direct from the people. Again, that's members of the civil society, and acting in their sovereign capacity. So right there, you've got protection under the law, protection under the Constitution, protection as the sovereign of the body politic, and protection as a natural human being on the planet Earth. But yeah, just continuing. So those laws which are made in pursuance of the Constitution come next. Decisional law would be after that, and that's because it's been determined that it's the judiciary's duty to say what the law is. After that, the next level's got 3 layers. So you've got federal statute concerning matters in persons of federal jurisdiction. You've got state statute concerning matters in persons of state jurisdiction, and you've got courts concerning specific instances. And beyond that, you've got administrative law or public policy, and this is essentially concerning persons under the direction and control of either local, state, or federal governments. So basically, after you understand the hierarchy of law, whenever you hear about, this new bill is being passed or being debated on, or that new decision's been handed down from some court or there, it always has to be put back to the test. Is something coming from an inferior authority contradicting something that comes from a superior authority? Because if it does, it loses all of its force at law. It has no force. And so, you can imagine, how many battles are we fighting over this or that legislation or whatever? Pass it, have your time, debate about it, doesn't matter, go, do it. And then when it comes to court, it'll be destroyed because it has no...
Or at least it should be.
Well, that's what we're here to make happen.
Awesome. Yeah, so before we move on to courts, I would imagine there's a number of cases now, probably literally millions of cases, where either the police officers that were involved, the attorneys involved, the judges involved, they never stopped to ask themselves whether or not the law or the regulation that was in question was in violation of higher order law, correct?
I don't think they have even the slightest idea about how to understand the law. I mean, I took criminology, in a very brief sense, leaving after one semester, but some of the things I learned, include that as a police officer, you've got no discretionary authority. You do not make determinations about anything. You don't determine what the law means or this or that. You enforce the law as you've been instructed, and the judge is the one who sorts out. Well, both the prosecutor have an obligation as well as the judge has an obligation to sort it out after the fact. But I mean, you can imagine that sounds more of like a practical career, teaching. You know what I mean? Something that comes from trying to pump out some career police officers rather than it does people studying fundamentals of law, like you might do with, like you'd imagine would happen with a law degree or something like that.
Right.
Yeah.
Well, so and I'll ask you one more question, and then I'll stop hanging you up on this. But would you say that right now we probably live in a system of law that is bottom up when it should really be top down?
Oh, very much so.
Okay. So, and for anyone who's watching, the clarification there being the bottom up, meaning the lower order law for some reason takes precedence nowadays, as opposed to higher order, where if it should be done accurately, it should be done from the presence of, does it violate, so what's the highest level? Is it God's law or so basically, does it violate essentially God's law or the highest level law? And if that answer is yes, then then you go further down the ladder. But if the answer is no, then you basically have to stop, because you can't then go further down the ladder to get to the lower end. But the way that we're doing it right now is we deal with some subservient or sub-order law, and if that's broken, like, the assumption is that you broke a law, which is not proper. Like, it's supposed to go the other direction, but now we're going bottom up. So, okay, cool. Did I say anything wrong there?
No, I'll make even a couple comments on that. You said really good stuff. I was going to say one of the reasons why that occurs is because when you're, learning, you're in school learning learning how to be a lawyer, there is major focus given to precedents. So to courts setting, a precedent, and that's like almost 100% on what they run with over there. Yep. You know what I mean? And the problem with that is you could have a Supreme Court set a precedent that's not actually valid because, like you said, it comes in conflict with some higher authority. But it's promulgated as the controlling decisional law because the Supreme Court passed it, which is an incorrect understanding of how the law works. But I was going to say one other part on that. Anyways, maybe it'll come to me.
That's okay. We got a lot to cover and we got a long time to do it, so don't worry about that. All right, so I held you up enough. Let's kind of move on to courts. So once we kind of like understand the hierarchy of law, how do courts factor into it?
So I was going to tell you this is like the idea about jury nullification. So in order to tell you about jury nullification, yeah, that's correct. We got to go back to courts. So in a very fundamental sense, a court is an incorporeal being that's constituted by the person and suit of the sovereign. And that's just a lot of words to say something very simple, which is it's a non-physical being. So it's not constituted by a physical building or by a particular location or anything like that, but rather the person, the physical body, and the suit of the sovereign. So the suit, that's a word that we get from Old English. So back when the king used to hold court, there used to be members of the court who would, be there and observe the proceedings, and they would act as a perpetual memory and testimony of what happened there. And they were referred to as courtiers. And over time, that name transferred to suitors, and over time that, they lost the end and it became just suit. And even the modern phrasing is just case. So all that means, suit of the sovereign, just means, the case that actually prompted constituting the court in the first place. Let's see. So yeah, our courts are adopted from. Oh, did you need to say something?
No, that's fine.
Okay. So our courts are adopted from the English legal system, and you might have read the Constitution, and in Article 3, Section 2, you might have seen the judicial power extends to all cases in law and equity, and you might have wondered what exactly does that mean, law and equity? Yeah. Well, that actually just refers to two jurisdictions in the English legal system, the law, so that's the common law jurisdiction, and equity, the equity jurisdiction.
Yep.
So basically, in the past, the king, England had the law, and this was promulgated by the king, and he established, judges to enforce the law. And over time, it became apparent that the king could not foresee every instance which his subjects might need, remedy under the law for whatever injustice. And so he created a new court, a new jurisdiction where he empowered chancellors, not judges, but chancellors, to dictate the law on the spot. And they did this according to what their conscience, said was fair, and according to equitable justice.
Yeah.
So in America, we have something very much the same. We have an equity jurisdiction, and our judges are empowered to dictate the law on the spot. Again, even if it's contrary to, statutory law or any other law, they're enabled to do this so that the outcome is the most fair and most equitable.
Yeah.
So you'd contrast this, however, with a court of law. In America, we've also got a court of law, and that's a court proceeding according to the course of common law. But a unique feature of a court of law is that the tribunal is separate and independent of the magistrate designated to hold it. And I understand that's a lot of fancy words, so let me just tell you what that actually means. So a tribunal is another word for the judge, and a magistrate is defined as a public officer invested with some authority of the legislative, executive, or judicial branch of government. So in a court of law, the judge is supposed to be independent and separate of the public official. Yeah, so
which means the fact that we have judges that are appointed, does that matter, or maybe the appointed judges is probably the correct way and elected judges is wrong? How would you kind of sort that out?
Nope, doesn't have anything to do with that. Okay. That's just a matter of how the judge gets selected. But what we're talking about here is what role the judge is performing. Okay. So you might wonder, if I've said in a court of law, the judge is not the public official, so who's the judge, right? Well, that would be the jury. So in a court of equity, the jury is there to decide the fact and nothing else. That's their job. The judge, like I said before, is there to decide on the law. But in a court of law, the jury not only decides the fact, they decide as well as the law, but they also decide, on the morality of enforcing the law in that particular instance. And this is where jury nullification comes in. So in a court of record, that's what we call a court of law here. The jury is empowered to do that. However, in a court of equity, it's not so. So you might ask yourself, which courts are courts of record? Mm-hmm. Well, a whole slew of courts are courts of record, all the ones that you'd imagine. And two, most famous would be the municipal courts and the district courts. So how is it that you end up in courts of equity if they're on the books as courts of record, right? Like literally Montana statute. That's where I'm from. That's where we're operating. Yeah. And so you find that when you answer a summons, right, you get the summons in the mail or you get it from the cop who left it with you or whatever, and you go to court to answer it, and they ask you, whoever you are, you're charged with such and such, do you plead not guilty, guilty, or no contest? And what you're actually doing is saying, I agree to the mode and measure of redress, is essentially the jurisdiction, and I plead not guilty, or I agree to the jurisdiction and I plead guilty, or I agree to the jurisdiction and I plead no contest. So what you would need to do in that instance is you would need to challenge jurisdiction, because what this does is it causes their court to not be able to actually move one step forward. You might understand like a motion, right? Filing a motion, that's the same thing as moving a step forward. It's the same verbiage, and they're not allowed to until they prove on the record the authority of their jurisdiction. And they have no authority to use discretion to ignore a lack of jurisdiction. And so what you do if they continue on without proving jurisdiction is you countersue them in a court of record. Mm-hmm.
And so that is something that I think no one really ever hears, right? Like, though I think some of the people in the liberty movement understand the concept of, like, if someone, especially a government official, asks you a question and they're like, are you for or against it? They're actually kind of bypassing, not that they necessarily have to, or maybe they should, but they're bypassing a step as to, do you actually consent to enter into this decision in the first place, right? But so by asking you, yes or no, or guilty or innocent, they're kind of making an assumption, or they're making you make the assumption that, you're just stuck with this form of court and that you can't actually, change the venue or change the jurisdiction, when truthfully you can, and they're kind of doing something slimy and not allowing you or informing you that you're essentially consenting to something that you don't know you're consenting to.
Well, I'd say two things to that. You're absolutely right. But on the one hand, like I said, there's a lot of ignorance. And so, you can imagine they don't even understand what they're doing. They don't understand the final nuance or the finer, subtle nuances of the law. And so they're like train wrecks, they're just continuous train wrecks. But the other thing I was going to say was, when you're there, I'll even do you one better, right? A public official is a fiduciary, okay? And so if a fiduciary withholds material information from you, from the public, they're guilty of a fraud. So just them doing that, not only is it unconstitutional, not only is it, because they have to get here's another thing we're going to talk about later, although we're not going to cover it right now, are what makes a valid waiver. So you're going to learn that a valid waiver is constituted by things like known rights. So you can't have a waiver of an unknown right. It has to be intentional, an intentional abrogation of a known right or privilege. And it has to be done with voluntarily and with sufficient awareness. I think there's even one other requirement. And I think the word you were looking for earlier when you were saying like they kind of force you to make a false thing. Well, it's actually what they would call it is a presumption. They have created a presumption based on the fact that you have pled a certain way, or is it pleaded? Sorry. And that presumption is actually another violation of the law, because there is constructive notice. There is a constructive notice against the waiver of constitutional rights. Or no, there's a presumption against the waiver of constitutional rights. So any other presumption that they could form, this other presumption would basically cause it to lose all its force.
Yeah. So they're supposed to err in your, well, I mean, like, again, the idea is that they're supposed to err in your favor, right? Like, but they don't.
Yeah, that's another thing. Yep, that's even another set of it. So if there's any particular doubt, there's a lot of cases where this has come up. In the event of doubt, it's just supposed to be resolved in the citizen's favor. That's just how it's supposed to come down.
Mm-hmm. Yeah,
You'll see later.
And it hardly ever is, right?
Oh, well, okay, so you do understand, or maybe hopefully anyone who's ever sat in a courtroom has looked upon the situation and understood that this is a racket. This is a business. They're here to make the money, even just like how much time you're going to take for them to get the money extorted out of you is a matter of, cost benefit chart they're running over here in their head. You know what I mean? Like watch them interact with the homeless population versus people who pay money. You'll see a whole different story.
Oh yeah, yeah. They roll them through. There's no financial incentive, right? So it's just like
get them in and out. Yep, it's really
So all right. So as far as courts, is that everything, or did we leave anything out?
Yeah, no, that's it.
Okay. All right. So that's courts. All right. So then we have a third section here, and I'm going to pull the outline up again. The third section is specifically about what constitutes a U.S. citizen, or is it what constitutes?
No, well, actually, so a better heading. Sorry, that heading is just some specifics that are in there, but
that's fine.
This is something you might say just like abuse of legal terminology. So,
okay,
if you want me to tell you about it, yeah, I'm ready to go. I could tell you.
Yeah,
about it.
Yeah, go for it.
Well, it's probably one of the more significant things that we found, and that's just because we've had the opportunity to take a few of these ideas to court or to actually try to utilize them, and we've seen the reaction, or we've received in response, what legislative authority they claim gives them the power to do the actions they're doing. Mm-hmm. And on all of the different material that they've provided, we've been able to find that they're definitely incorrect. And so it's really great. So most of what they use to justify violations of individual rights are really a matter of abusing the construction of legal terminology. And I understand you may not be familiar with the term construction as I've used it, but that essentially just means the act of construing, interpreting, or explaining. So through the abuse of construction of legal terminology, they create a thin veil of legitimacy behind which they violate individual rights. So, like, for instance, I guess if you want to go through it, the first one there is the term person, and it includes only the corporate artificial entity, but not the natural-born human being. According to the fundamental principles of law, almost all laws, regulations, and statutes that refer to the person do not refer to the natural person and do not extend any lawful jurisdiction over them.
Interesting. Okay.
Yeah. So another one of those is a 14th Amendment citizen, a U.S. citizen. It's actually a property of the federal government in the form of a franchise and as a corporate entity. And a franchise is a special privilege as conferred by government. And something interesting, an excise tax is a tax on corporate privileges. So an income tax is an excise tax. So when you're there filling out your W-4, and you're saying on there that you're a U.S. citizen, you're actually, telling them or creating creating an excise tax liability on the basis that as a U.S. citizen, you're a corporate entity. So occupations which are of common right, so that's just any of the common occupations of life, though, cannot legally be taxed and excised. So this is because income is defined to mean gain, and gain is something that you get without giving anything up. you get nothing in return for that. So if you're at a job and you're laboring away, you're exchanging your labor for compensation. I mean, listen to the word compensation. It's literally compensating for what you've given up.
Right.
And so compensation, or so wages, salaries, and compensation for services have been held that they are not income within the meaning of the law. So let's see here.
So now, is that another situation where you're basically unknowingly signing away a status? Like, so,
Yeah.
like you bring up the example of filling out your W-4. So the actual act of filling out the W-4 is kind of signing away tax-protected status that you would normally have.
It's creating a false presumption, and exactly what you said. Yep, it does take away a tax-exempt status. So you might see, I've written there, revenue laws relate to taxpayers and not to non-taxpayers. That's actually in the law. So you ever wonder why it is that you can't, find the tax paperwork that helps you to say that you're not exposed to any tax liability? It's because they don't create tax forms for you. There's no reason why they should be targeting you, and thus there's no reason why you should have to explain why you don't need to be targeted by them. But it's so crazy, the ignorance and the racket, that they're targeting everybody. So
yeah. Okay. All right. So then you have the next point is U.S. citizen versus de jure.
Yeah, so you'd contrast U.S. citizen with a de jure citizen of one of the states of the Union or a natural-born human being. So, for instance, a U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce as a resident and does not have the common law right to travel of a citizen of one of the several states. So this would expose you to the police power, right? So how's our time looking? Are we doing okay for?
Yeah, we're doing right. We're okay.
Okay. So the next one I have here is just that Title 26 of the United States Code defines state as the District of Columbia for purposes of income taxes. Trade or business is defined in Title 26, the U.S. Code, as functions of a public office. So when you're there at your job, are you performing the functions of a public office? Then you're not participating in a trade or business. Or I'm sorry, trade or
trade or business, right?
Yeah.
But so in that case, I guess we could delve into what constitutes a public office. I think most people would assume that means
we'll get into that.
Elected or publicly funded.
It doesn't. It actually means the key test is whether or not the position exercises some sovereign authority of government.
Okay.
So a CEO, that actually would, of a corporation, right, having their charter powers and their existence actually, caused by the state, they would be included within that, but so would a government official and so on.
Okay. Yeah. All right. And then the next one is employee being defined as an elected or appointed officer or employee. That means basically just the C-suite are technically employees, everyone else isn't?
I didn't hear your question. Could you maybe restate it?
Yeah, sure. So the next point, Title 26 says that basically an employee is defined as an elected or appointed officer or employee. So that essentially means that in a business, it's just the C-suite, like the senior officers that are technically employees. Everyone else isn't.
Exactly. Yeah. See, I've never heard that word before, or that term C-suite. But yeah, that's exactly correct. Yep, you got it right on the head. But it, as I said, it also include government officials. Yeah. Totally.
Okay. All right. What do you got after that?
So I guess, and so that's the Code of Federal Regulations, in case you didn't know what the CFR stood for. But in Title 18 of the U.S. Code, get this is my favorite one. The territorial jurisdiction of the United States is actually defined to include only lands outside the boundaries of those belonging to any of the 50 states of the Union. So, right?
Well, this is like the Articles of Confederation versus the Constitution here, right? So, like,
in a way, may I?
Go ahead. Yeah.
So actually, what I was going to say is just the same way that you're thinking, about the heads of those companies, right? The territorial jurisdiction, it wouldn't simply be it is true that it's the lands outside of those belonging to the 50 states, but it doesn't mean that a federal person couldn't enter into those 50 states and still maintain or be the object or have liability to the federal government or the federal laws. So that's generally what you're looking at, like a person incorporating, their business. You see what I mean? Or like,
well, this also goes hand in hand with the 10th Amendment, right? I mean, it's essentially it's trying to maintain state sovereignty. Now, in terms of, and again, we're kind of digging into this. We'll dig into it at a later date. But does the timing of this also matter? Does it have to do with like the Louisiana Purchase or anything like that?
I'm not familiar with what you mean, but what you said just now makes me think that maybe I didn't actually clarify that properly. But
Okay.
Just to try again, the ability. So what you're seeing, right? What I just showed you is that the territorial jurisdiction is outside the states of the union, right? So you're thinking, oh wait, but what about all these people being exposed to this, right? So I'm trying to introduce you to the fact that it's not just based on where the jurisdiction is. The jurisdiction can also be based on a person. So even though, you know what I mean? So that person, if they go into some other jurisdiction, so like Julian Assange, right? It's gone into another jurisdiction of another nationality, or I apologize, he's come back or whatever the case is. But when he did that, right, they're still maintaining control over him. You know what I mean? If they could get him back, that's what they would do. So the idea is just that even though they're going into the state jurisdiction, they're still an object of, they still have liability to the federal government. But again, as we've kind of discussed, most of that is based on false premises and presumptions at law that they are not actually legally allowed to make.
Okay, that makes sense.
Cool.
All right. What is a driver?
So a driver is actually defined as operating or an individual operating an automobile for commercial purposes, and it excludes explicitly the operation for private non-commercial purposes. So you can imagine how many of us, oh, you're gonna drive to the store, you want to take a drive down to the lake, or like all of us, we use this, and they do this intentionally. There's an obvious historical record of the perversion of dictionaries, both legal and common, where you can see that it's just totally a scheme, and we all use the verbiage, the incorrect language, and we don't know any better. We don't know to check the definitions at law. And so you can imagine the consequences. We all think we're talking about the same thing when really, it's not at all.
Yeah. And so this kind of goes hand in hand with the next point, right, of a motor vehicle. It excludes operation of anything like an automobile for private, non-commercial purposes. So basically, like me getting in my car and driving to the grocery store, I am not technically a driver as it relates back, and I'm also technically not in a motor vehicle.
That is correct. You are operating an automobile. And in fact, it's actually a jury question whether the automobile is a motor vehicle at the time. So the controlling case, I believe, says the primary use to which the vehicle or to which the automobile is put is what controls. So if for 51% of the time you use it for commercial purposes, then it would be, and if for 49% of the time, it would not be. But again, it would be a legal presumption, that allowed them to stop. So the first thing out of their mouth would be, confirming with evidence from a competent source. That would be you, because they don't know your mind. They don't know where you're going or what you're doing. So they cannot provide a testimony which is competent to any degree. It cannot be considered competent evidence. And that's all the information, the ticket that they give you. It's actually an affidavit, but it's called information. And that testimony on there is a sworn testimony, basically saying this is what, is the case. So that if the cop was found to be lying, they would be guilty of perjury, right? And this is how our legal system stays, good to go, because everybody's liable to what they do there. And so, but they use that information, that piece of paper, called it information, as an affidavit as credible, competent evidence when there's no possible way because they don't know your state of mind and they didn't ascertain the fact, But we'll get into all of that when we kind of delve into that particular.
That's going to be a good one. I'm sure a lot of people will be interested in that information. Okay, and what's the last bullet point you have there before number four? It says,
I just wanted to say that's really great because that's actually our first project that our employees currently working on. So
okay,
we're really excited about that one. Yeah. So, you know what? I just that one is kind of a little. I could read it. So the term includes, used in statute, is a word of limitation as well as expansion. It expands by introducing the specific elements constituting the enlargement. It thus and thus only enlarges the otherwise more limited preceding general language. So that I figured it was going to be too difficult for people to understand that I was just going to skip it, but I have a pretty good illustration, if I might. So you could say the term fruit is defined to include apples, and by saying this, you would also be, by using the word includes, you would be expanding the definition as well as limiting it. And in the sense that you'd be expanding it, you would be saying, any other type of fruit as well as apples are also fruit. So oranges could be fruit and bananas could be fruit, but, corn or a car, those could not be fruit. And so as you use the word includes, it limits based on apple. What is the general category that apple falls into that allows you to determine, what the other things that are included within that category are also included.
So let me call time out and just put it into what I would say is my own words. Okay. So if I have a group of things and I want to expand on that group of things, I will say this group of things is whatever includes or including this other thing. And you're saying that the one other thing that you're including is kind of like the filter. It's the measuring stick by which you're allowed to increase that group of previous things. And so there's not kind of like this without bound aspect to it, right? Like there is only a very small or finite amount of expansion of that first group of things based off of that one thing I'm adding. Is that kind of right?
Yes, and the limitation to that expansion is, again, that category. So like another example might be that you could say numbers include 1, 2, 3, 4. And using the word include, you're saying it also includes, 5, 6, 7, 8, and so on. But you would not be saying that it includes A, B, C, D. Does that make sense?
So, yes. Yeah. So how does that factor into, say, like a situation where I'm pretty sure you're going to tell me it's improperly used?
Because people include, and especially law enforcement and the judiciary will read. They will read include in statute, and they will think that it's expansive without any limitation.
Okay. All right. So before you give me a good example of that, looks like you have a family member, S. Hinkle, who's watching. And yes, there will be a recorded version later on that you can watch. So awesome. But yeah. So I would imagine that has to do with what, an expansion of liability? Is that typically the way it's used, or is it used in a different way?
When you say liability, are you just saying trying to get you for something else? Trying to expand you included in the definition when you otherwise should not be included in it?
Correct. Yes.
Yeah. Then yeah, accurate. Yeah.
Yeah. Okay. So I'm pretty sure there's a number of instances that happens. Correct.
Oh well, yeah. I mean, even just like the term trade or business. So, like I said, it's the performance of functions of a public office. Well, the way it actually reads is it includes the functions of a public office, but you can scour the entire Title 26, the Internal Revenue Code, and you will not find another definition or qualifying statement that defines what trade or business means. So it's just, sneaky. That's all it is. They've really done the work, and they've had a lot of.
So you're saying when it says trade or business including public office, and then it doesn't give you a definition elsewhere, technically that should revert to just a definition that means public office.
Right.
Yeah.
And only things that also come within that, genus or category. Yeah.
Okay. All right. Makes sense. Awesome. Okay, so that's kind of like some more specific definition type work, I guess, that we can look at. The next section you have is legal remedy. So we're talking remedy in terms of what? An individual's ability to, be punished or sue the government.
To hold the government accountable, I would say.
Okay.
Yeah. So,
all right, so what does that start off with?
So let's see. So I was going to say, I pretty much was just going to read through these because they're almost exactly word for word taken from many different cases. And, from, like I have written here, established decisional law, statute, or legal principle. So it's pretty much as straightforward as it can be. But if you want me to stop on any particular one and talk about it or explain it a little more, please just let me know and I'll do that.
Go for it.
Yeah, so the first one there I think is the best. So it's the duty of all magistrates to exercise the power vested in them with zeal and fidelity. Fidelity is defined as accuracy in details and is often a condition of the oath of office. So they're actually oath bound to be accurate in the details of the construction of legal terminology, like we were just talking about. So you can imagine how significant this is, right? The fact that they are actually required to know what all the words mean. They're required to have accuracy in the detail of every single definition that they're using. And to not do so is a violation of their public oath or, their oath of office. So it's a pretty hilarious, got you by the, cojones situation.
I'd say so.
Yeah. So the next thing is a public official is an employee, and the execution of the oath of office is essential to the status of de jure employment, the lack of which precludes the right to compensation for services rendered. So essentially, if the public official doesn't execute his oath, he's not an employee, and he loses the right to be compensated for his services. So
awesome.
Yeah, right? You could imagine that would probably change quite a few minds, make them, stand up and pay attention.
Most definitely.
Officials and judges cannot claim to act in good faith in deprivation of law. So they can't say, I'm pretty sure this is what the law is. I'm going to go ahead and move forward because I'm pretty confident and not check it. They are required to check it. There is no claim. Well, that is to say they're not required to check it, but they're certainly opening themselves up to legal liability if they don't. So,
and that I think, and I'm sorry if I'm stealing your thunder from later on, but that can also be up to and include personal liability, right?
Oh, well, it's all individual. Well, here, look. Okay, so I wasn't going to talk about this, but in a nutshell, the government can do no wrong. The government is a perfect entity. And the way that works is that any agent acting in the name of the government who does some kind of illegal act or who causes some kind of violation of individual liberty, they're actually acting under color of law. And I'll talk about that a little later. There's a definition in there. But they would be sued in their individual capacity and not in their official capacity. And that's really important. So that means, no, you don't get, the fancy state defender. You don't get, the this or that. You don't get all the support that you got. You don't, you don't get to have the state pay for it if it, which is really the citizens, right? Mm-hmm. You don't get, if you're found guilty or if there's some settlement or whatever, you don't get to have the state pay for it. That's all out of pocket. So you better pay attention to what you're violating and not violating,
I wish that was applied more more consistently.
Well, you'll see there's a big we're going to get to it, but there's this thing with qualified immunity, man. Everybody really has the wrong take on that, but
yeah,
if we go through this, you'll see what I mean. When we get to it, I'll point it out and you'll see.
Okay, cool.
Okay, so in fact, I think it might even be one of the next couple. An officer, or let's see, when lawsuits are brought against federal, no wait, where am I?
Very top of the page. There's no such thing as ignorance.
There's no such thing as ignorance of the law, and they even have said this, that officials and judges' pleadings to this effect are ludicrous. I just got such a kick out of that. So public officials are under constructive notice and implied notice to understand all of what we've talked about so far.
Okay.
So, yeah. A neglect on the part of a magistrate to exercise the functions of his office when required by law is a misdemeanor. When lawsuits are brought against federal officials, they must be brought in their individual capacity and not their official capacity. When federal officials perpetrate constitutional torts, they do so ultra vires, or beyond the powers, and they lose the shield of qualified immunity. So that right there, and there's a lot of case law behind this, but a lot of people have the idea. Like, I mean, I saw this tweet from Kamala Harris that was like, we need to end qualified immunity so that we can get justice for excessive force and these other, and these other things that were just already against the law, which are like, you don't get to have the shield of immunity. So you can just imagine the ignorance that is going on, or maybe it's all just a play, right?
Yeah.
What can we say to keep the racket going?
Well, you're saying it's basically a mirage that everyone thinks is there and keeps fighting, and really, we don't have to. Like, it's not even there, right?
Yeah,
like it's
absolutely.
So, and the other thing that this brings to mind is, in a lot of capacities, public officials ask the public entity that they're working for to essentially give them coverage or protection in their official capacity. And what you're saying, that the law actually doesn't allow that. So even if they officially extend that coverage, they're not allowed to.
Nope. And so, well, here's the thing. There may be a case, see, like it says, you're supposed to bring the case in its official capacity, in its individual capacity, suing them in their individual capacity and not official. And so it would be completely justified. I could imagine potentially, I have not read all the cases that are apparently abusing qualified immunity, but it could be potentially that, one of those instances, there's, someone not suing the right entity. So you're not suing the police officer such and such, you're suing the individual such and such. And that small difference, will make a judge say, nope, that entity has no liability to you. And another judge in the other question, right, or the same judge with the other question would say, yep, absolutely, that guy acted beyond his capacity, You know what I mean?
I gotcha.
Yeah. So, let's see.
I think the next couple of ones are in line with that, right? Like, an officer can be held liable for damages to any person injured in consequence.
Yeah, so this one is actually interesting. It's pretty significant because, wait, hold on. Okay, so this one has to do with the breach of his duties. So if there was anything that he, was required by law to do, or that was in his job description and he didn't do, then that would be, so this is just another cause for, or, way that they could be open to liability for how they're performing their job.
Okay.
So in cases where officers act without authority of delegated power, a claim of error in the exercise of that power is not sufficient. So I find that pretty significant, that, like, you may not, you can't act in good faith. You are under constructive notice to know the law. You're oath bound to understand what all the different, intricate aspects of the law are. You don't get to, since you're oath bound to do that, and you don't do that, you don't get to claim, that you, get to have your pension or any of the checks you've been collecting. And you've actually got to pay for these legal damages that you've just done. And, in this particular one, you can't even say, like, oh man, I'm so sorry, I didn't mean to, it was an accident, like, nope, that doesn't apply here. You went beyond your authority. And so it'd be like someone who went to rob something and their gun went off when they didn't intend for it to, and they killed someone. And then they went to say, oh, I didn't mean to kill them, because they can't claim error in robbing the store. Oh, I didn't mean to rob the store better. You see what I mean? It's almost like that, So, let's see. I keep losing my spot. I'm sorry. So, get this one. So this one is great. So this one, if an officer of the government wrongfully takes or holds specific property to which the plaintiff has title, then his taking or holding is a tort. It just means a cause to go to court, file an action. And illegal as a matter of general law, whether or not it be within his delegated powers. Do you get that?
Yes,
So
yeah. So that basically means that police confiscating, say, personal property can be held personally liable regardless of whether or not it's within their role.
yes, exactly, because the authority above them giving them their role cannot authorize them to violate the Constitution or the laws or so on.
Awesome. All
Yeah.
right.
So get this one, dude. This is so great. So there's a few that go along with this one, but I just put it with one sentence. But shall, right? So the term shall, used in statute, may be interpreted as may in order to avoid unconstitutional doubt.
Let me wrap my head around that one. All right. So shall in a statute can or may be interpreted, not must, but may be interpreted as may in order to avoid unconstitutional doubt. So basically, in a situation where the constitutional rights of the individual are at question as to whether or not they've been violated, anything that says shall, that's like black and white, should now not should but may be interpreted in a different way so as to avoid that unconstitutional doubt. So this is that err on the side of the individual. Is that right?
The other ones that say err on the side of the citizen, those are all in themselves. This one is another one that just goes along with it. That, it just essentially is, I just like it because as far as constitutional doubt, so it's not a matter of whether it is or isn't constitutional. It's literally like it's up for debate, We're not sure whether it is or isn't. And even those are, the judges are empowered, and you can imagine this is also the officer, right? Because the officer reads the statute. He's got to employ the law, right? He must enforce it. That's his job. But if the law allows him to change shall, he can easily say, you know what? I actually not required to do this. You may or you may not,
And you know what? What's funny is the majority of them almost make the assumption the other direction. They make the assumption that they have to interpret it as shall, because if they don't, then on appeal or something like that, they might have one of their rulings overturned. But this is essentially saying that that agent in the state or whatever, or that kind of like magistrate or whatnot, really has the power to interpret it in the favor of the individual. And then what's funny is and again, for anyone who's watching, this is why it's so complicated. And correct me if I'm wrong, Josiah, but this also relates back to earlier parts of it, right? So if they do choose to interpret it as shall, but then they do it improperly to the detriment of the individual, they could then become personally liable for that ruling. Is that right?
Oh yeah, absolutely. And I wouldn't say they could become, if your premise was that they did violate it, right? It's not that they could become, they would be liable. And it would just be a matter of you going to court to cash in on that liability to hold them accountable.
Wow. Okay. Awesome. Yeah, no, we could definitely dive into that later. That's really powerful. All right. So what about this one? Person in statute
is ordinarily meant to exclude the sovereign. So when you hear, you're reading the statute, like the motor vehicle one, right? A person will register a motor vehicle, or I don't even know what it says, but such and such, right? And ordinarily that's meant to exclude the sovereign. So, to what degree does that enable them to enforce it on normal people going about their private business? Well, it makes sense for a commercial entity, right? It doesn't have the right to, operate a commercial business on the roadways without permission from the state. And so,
but so that basically means that the assumption here is that whenever it says person, the default is to exclude the sovereign that hasn't essentially established themselves as a person, which we earlier said does not have the definition that most people think it does.
Right. Yep, that's exactly right. Sorry, I kind of trailed off there.
No, that's okay. That's all right. And then the next one is an intangible right to honest service. What does that mean?
Just that Well, it's just like we mentioned before, common moral principles like goodwill, or I'm sorry, not goodwill, good faith.
Hmm.
Essentially, that just means, action taken without, malice or intent to defraud. So it's just like a genuine action. So you can imagine, as I make a contract with you or something, like if I go to meet a friend, in the park and we arrange to do that, I'm not, arranging that meeting so that I can, attack them or take advantage of them or something. I'm genuinely wanting to meet them in the park, and there's no malice or fraud that's going into that behavior. So the idea of the intangible right to honest services is kind of linked to that. That
Okay.
everything, all interactions require good faith.
Okay. Awesome. All right. Let's move on down the list here.
All right. So to take away all remedy for enforcement of a right is to take away the right itself, but that is not within the power of the state. And so if you remember when I was talking to you in the beginning about how I got these law books, right? So like I got constitutional law practices or practices and policy, and I got like a few different West Group books, like tort law and yeah. Anyways, a few different books and some a legal dictionary that's the 7th edition Black's Law. And it wasn't until I went back to 5th edition where I started to see some really good stuff. And yeah, so like I said, reviewing all these books, they kind of left you just like hopeless. Like there's nothing you can do. There's no teeth here. And so that right there, that resonated with me so significantly, because it's like what they've done is to take away our ability to enforce and assert our rights, and that's not even within their power to do. So
That's incredible. Awesome.
I know, right?
Okay.
So the next one, if the state converts a right, or otherwise known as a liberty, into a privilege, the state can ignore the license and ignore the license. Sorry, I've kind of got the sun in my eyes, so I can't see.
That's okay.
Ignore the license and fee and engage in the right with impunity. So do you hear that?
Yeah. So it's basically for instance, just taking the driver's license example, right?
Yeah.
And the fact that if you are not technically considered a driver or operating a motor vehicle, that if the state tries to turn that right of operating that automobile into a privilege, that you just have the right to completely ignore it, and any fee that's associated with it.
As well as with impunity. And what that means is there's no possible legal liability that could go along with it.
Fantastic.
Yeah. So the next one, when a judge acts as a trespasser of the law, when a judge does not follow the law, the judge loses subject matter jurisdiction, and the judge's orders are not voidable, but void and of no legal force or effect.
So essentially, if a judge commits any kind of infraction, up to and including these things that we've talked about before, that essentially it voids out that judge's authority.
Yeah, so think about this, right? So when the proper definition of person doesn't actually include, what you are, and they're trying to expose you to the liability of that statute, right? They're actually breaking the law, because they're imposing the law on someone who has no liability to it. And
wow, okay.
Yeah, right. And I hope that I'm sure it was very obvious, but I really just love the not voidable but void. So it doesn't need any higher authority. It doesn't need any determination. On its face, it is void and of no legal force or effect. So
yeah, doesn't get more exact than that.
right. So a public official is a fiduciary toward the public, and if he deliberately conceals material information from them, he's guilty of fraud. So that's what I was telling you about earlier. And it goes even better than this. On the next one, silence can only be equated with fraud when there's a legal or moral duty to speak, or when an inquiry left unanswered would be intentionally misleading. How many times? I don't know if you've ever, are you familiar with the tax movement? Like Aaron Rousseau and Freedom to Fascism?
A little bit, yeah.
So, you can, I don't know if you remember, that movie in detail, but dude, he's standing there on like the floor of the IRS talking to these different officials saying, is there a law that makes just a normal individual liable to the income tax? Because they found much what we found, right? That
Yeah.
the income tax is an excise tax, and you cannot apply that to occupations of common right. So, they're there for a good, I don't know, 20 minutes of the video. So it's overly edited. They're probably there all day, but they're like, can you tell us the law? Is there a law? And none of the times they're like blocking the cameras and pushing people out of the building. They're like, you can't film here. But not a single time did they take the question seriously and answer it. And so this thing right here, an inquiry left unanswered would be intentionally misleading. Holy cow, right?
That's exactly what they did.
Yeah, exactly. It's like breaking the law. So as I study all this stuff, just to give you guys like, oh man, what gets me so fired up about it is that like the law solves all the problems that there are. Like granted, there are some practical issues we've got to face. There's ignorance out to wazoo, all of that. But like as you read the law, it's beautiful. It's like perfect already. You know what I mean? And you can see so many issues already that you could solve if the law was actually properly enforced and intelligently obeyed.
No, that's fantastic.
Yeah.
The next one has to do with fraud.
So fraud destroys the validity of everything into which it enters. So do you remember it was saying that if they withhold material information from you, right, it's considered a fraud. So for them to say you actually did do something, and I don't know. Well, I'm not a legal expert, so I can't say like definitively, right? I'm just like, yeah. But essentially, the way that I see this is like, if you do something like you were speeding, and they pull you over and give you a speeding ticket, right? And then later you went to court and maybe you even pled guilty. You're like, yeah, I was speeding, they caught me, I'm not going to argue it, and all of that. But the fact that the DMV did not tell you that it's a natural right to operate an automobile at the same time that you were there under the impression that you had to get the driver's license in order to operate an automobile, that's a fraud. So everything from that, or say we don't even focus on that fraud, right? Let's say all the way now we're back to the judge. Before the judge, does the thing, and the judge doesn't tell you, oh, you've now entered into a court of equity, or by agreeing to the statutory jurisdiction, that's what you're doing. That would be a fraud. So even if the DMV was to say, hey, you gave up you don't. But if it would be the case that they were to say, hey, did you know you have the right to operate an automobile without any license? And you were like, yes, I do. I'd love to get the license anyways. And you got the license, and then you were speeding, and then you were pulled over, and you do all this, and you get to the judge, and the judge didn't tell you about the court thing, right?
Yeah.
If he withheld that intentionally, that would be a fraud, and it would go all the way back. You see what I mean?
Yes,
it doesn't mean it wouldn't have the license. I just mean it would affect that entire proceeding.
Well, yeah. Well, so they couldn't stand on the fact that you volunteered to get the license when at a certain point during that proceeding you were essentially defrauded,
Right.
Which I love about it. I wish it was consistently applied, but yeah, no, I think that's fantastic.
You can imagine education is really the key here, right?
Yeah.
So advocacy to a certain point, we're going to bring our, dotted I's and crossed T's and our best, reputation, put that forward to go talk to the government. We're going to try to set things straight. But really, our organization is thinking that the solution is going to be a long-term solution. And it's going to come from primarily educating the public. And as those, high school and college graduates go into professional degrees or practice, they're going to be able to, bring this knowledge to the forefront of practice, right? And the people who are kids at that point, as they grow up and as they become exposed to the system this way or that way, they will be in a position to demand from the government the proper enforcement of the law.
Awesome. Yeah, no, I love that. Do you have time? We're past an hour, so do you have any more time?
I have totally enough time to finish this up if you'd like.
Okay. All right. So the next one we have has to do with extortion.
Yes. So extortion in the Hobbs Act is defined as the obtaining of property from another with his consent, induced by wrongful use of actual or threatened force, violence, or fear, or under color of official right. So that's the main one that we like to look at. So color of law, that's the next line, is defined as the appearance or semblance without the substance of legal right. Misuse of power, possessed by virtue of state law, and made possible only because the wrongdoer is clothed with authority of the state. So this is essentially all of the instances where an officer or a judge or a prosecutor or whomever it is says, I have the authority to do this, violate your rights, X, Y, Z. Yeah, that's called color of law, and it's extortion.
And you're like, no, you absolutely freaking do not.
You do as long as you want to be liable for extortion. Yeah.
Right.
everything comes down to liability. You know what I mean? What can you hold them accountable to?
Yeah.
You know? Yeah. So I love these last two. So these are 18 USC. They're kind of cumbersome, I know, but let me read them out to you. So section 241, conspiracy against rights. If two or more persons conspire to injure, oppress, threaten, or intimidate any person in any state, territory, commonwealth, possession, or district in the free exercise or enjoyment of any right or privilege secured to him by the Constitution or the laws of the United States, or because of his having so exercised the same, they shall be fined under this title or imprisoned for any term of years, or for life, or both, or may be sentenced to death.
Okay, yeah. Hold on. Do you want to do the second one first? Or
no, let's do it. So section 242, deprivation of rights under color of law, right? We were just talking about color of law. Yep. Whoever, under color of any law, statute, ordinance, regulation, or custom, even custom, right? Even custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States shall be fined under this title, imprisoned for any term of years or for life, or both, or may be sentenced to death.
This is like, this is like the validation for people during the French Revolution bringing out the guillotines, is what it sounds like. Right. Understanding that there needs to be a legal process here, but
you know what? Actually, you know what's really cool? Could I take like a 2-minute tangent?
Go for it.
Something that's actually really cool. That's the cause for most of our, enslavement is actually the 14th Amendment. So originally, what you had were states. When they passed the 13th Amendment, the states maintained, abusing Black people by passing different codes and statutes that were definitely violative of their rights. And then when it came to the juries, right, in courts of law, it hadn't been perverted by that point, but in courts of law, the juries would uphold the law and violate the rights and say, nope, you've got no recognized rights, So what they did was invented the 14th Amendment, and that created a new class of citizen, right? As we said, it's a property, a franchise of the federal government. Now, if you're messing with federal property, if you go blow up a federal building, do you want to know what's going to come down on your head? It's like all the force of the federal government, right? 100%. Well, that's what happened, right? They're actually offering to citizens, Black people, the ability to have all this protection, right? For the ability to live their lives, unencumbered by what these states were trying to do. And eventually that ended up being directed toward Native Americans in the allotment and assimilation period, and basically eroded a lot of their sovereignty, and then it was directed at white people. And now we've just got the whole slew of it. Essentially, in the 50s, it became about business and corporations. So that whole occupations of common right things covered up. But yeah, so it's pretty interesting.
That's also, what's interesting about that too is you made me think about the fact that, and maybe this is not a valid argument, but I mean, you could make the argument, at least back then, that anyone who committed an atrocity against someone who fell under the 14th Amendment, that they were essentially damaging federal property or a person of the federal government?
That was exactly the argument. Yep, that was exactly it.
Yeah.
That was how they ended up being protected. But then you see how the government ended up abusing black people, right? And then now we've got civil liberties, which are just a reestablishment in the civil, authority of the natural laws that were recognized under the Constitution and the Bill of Rights.
Yeah.
It's a really funny situation.
This is like a dog chasing its tail, because in so many instances, and you probably see this way better than most anyone else, but in so many instances, whether it be the subprime crisis, whether it be any of the financial issues beforehand, some of like the securities cases and fraud and stuff like that, a lot of regulation and law has resulted from that. When truthfully, the common sense answer was you just had to enforce what was already on the books, right? Like what was already in place.
Well, okay. Remember though, we I'm sorry, I cut you off.
No, go ahead.
Well, I was just going to say, remember, something. Well, we didn't really talk about this. We'll talk about it later. But in the 1850s, when they introduced the codes, we actually adopted those from England. We didn't have statutes in the beginning. We had the common law, which basically was 11 main causes of action, which moved to court. And so it was super simple. But they argued, it would be better if we brought the code system. So anyways, with that came the practice of lawyers. And so before this, you didn't have an official lawyer. In the law, you cannot litigate on behalf of another person's rights. That's not a thing. So you can do your own case for your own rights, but you can't get another person to do it for you. So there wouldn't be a lawyer profession. That's not a thing, But in the equity jurisdiction, it is. And so they go to school and they learn how to be a lawyer, which means how to represent someone in the equity jurisdiction. And as we talked about how they become judges, you can see how a whole slew of bad decisional laws come down because nobody is the wiser, and until someone challenges that decision, it's not going to be written on the books that it's been taken off. It may be true that at any case you're going to litigate, it is invalid, but it's not been determined by their court system to be invalid yet. So it's still there in the books. And we all look at it saying, oh, they passed down these decisions, but that doesn't matter. As soon as someone challenges it, it would be defeated, right? But they don't challenge it. What they do is they change their behavior so that it's in line with it. And they make it the new way everyone is. You know what I mean? Because they don't want to, who's going to relitigate something that's been litigated and decided, right?
Yeah. And so that also brings something else up that and right after this, we'll get to kind of, legal remedy. But the idea that if you represent yourself pro se, right, the assumption, or how should I put it, like there's not an assumption that you're supposed to know the law. So anytime you screw up as a pro se defendant, right, like even if you screw up, that can't be held against, or it shouldn't be held against you in terms of the way that you're defending yourself, correct?
Nope. So I was going to save this until later. Again, I don't know how deep you want to go in on this, but so there's something fundamental. So I'll say two things about this, but there's something fundamental about the law called substance and form. And we actually talked about it with Color of Law. It said the appearance or semblance without the substance of legal right. So there's substance and form in the law, and substance is what actually gives you what actually creates the legal rights or liberties. And the form is essentially how those rights or liberties are asserted or accessed. So just a really good example is, it may be your right to such and such, but when you go to the court, you probably don't put it in Chinese script, you put it in English, and, you see what I mean? You're following, you see what I'm saying? You're following a certain format and everything. So that's form. Yeah. The fact is, at law, form never trumps substance. And so it really doesn't matter how. You could have written it on sticky notes, 1,000 sticky notes, and it really doesn't matter. You could have written it in Chinese. It doesn't matter, because the substance of the matter is what gives your claim all of its force. And the other thing I was going to say on that is there have been many pro se cases that have gone to Supreme Courts. And I remember some of them even say like the 150 page. Okay. You should understand that court cases are like complaints, are like 16 pages at most, right? Like if you can get it in 2 pages, you're like golden, that's good, because the judge doesn't have to read it, take too much time to understand it. But the 150-page pro se pleading that was submitted on behalf of plaintiff was called inept by the Supreme Court judge. However, it was still held to be not completely valid in the way that that everything he wrote was valid, but valid in the way that the substance of the matter was not disregarded, despite his pleading having been considered inept. 150-page pleading, 10 times the size that the maximum normally is.
Yeah.
You know?
No, I love that aspect to it. So yeah, we can definitely get deeper into it. We can chase our tail a lot on this stuff. But okay, so let's talk about the very last aspect of it. Basically, violations of the law and essentially remedy, right?
Well, the remedy is all of that stuff from before. So the
that's
things
right.
from
Okay.
before basically are things that hold them accountable, and you could seek remedy under.
Okay.
These things are violations, basically saying these are things that open them up to liability, to some judicial liability, right? To some legal liability. So an illegal arrest is an assault and battery. So
100%.
Okay. I actually took this off. So we don't like to promote, we're absolutely 100% against violence. So we do not endorse or promote anything like, making violent enemies of the government. That's not what we're about. We're actually thinking that this whole thing is a big misunderstanding. And if we, bring our best rapport and our best, effort, we can be friendly and we can convince them to look at the law. And once they see it, they can know that they can change their behavior, based on sufficient authoritative evidence,
Understood.
But to finish it off, it actually says something to the effect of, and they can combat that assault and battery just the same as as they would any other assault and battery. So of course, it's going to open you up probably to get shot in the chest by cops. So don't do it.
Yeah. You'll be exonerated later after you're dead.
After you're dead. Yep. Unfortunately, that's the case. Yeah. So anyways, but so the second one there, a state may not impose a charge for the enjoyment of a right granted by the federal Constitution. One cannot be punished for failing to obey the command of an officer if that command is itself violative of the Constitution. For example, certain police stops to identify an individual without warrant or probable cause. Being violations of the Fourth Amendment, they are not empowered to do that. They cannot simply stop you and ask you to identify yourself without thinking that you're involved in a specific crime or in some specific criminal activity based on probable cause or a warrant they've already acquired.
Okay.
So that's significant because where I come from, cops are going to stop you all the time for no reason but to identify you. There's nothing that they could say you're doing illegally. They just think they have the right to identify you. And so when I read that, I was just like, well, I'll be, So what's the next one? All public officers owe a fiduciary to the public, and all public officers labor under every disability and prohibition imposed by law upon trustees relative to the making of personal financial gain from a discharge of their trusts.
Let me ask about that one.
Okay.
But so hold on, I'm basically going to kind of read it back here. So basically, all public officers labor under every disability and prohibition imposed by law. So basically, they have to abide by the law and how it essentially limits them or constrains them upon trustees relative to the making of personal financial gain from a discharge of their trusts. So is this basically a conflict of interest protection? Is that what this is?
It would be. Yes, it would be.
Okay.
So to whatever degree, obviously, it says imposed by law. So it would maybe be, up for judicial review what laws were legitimately passed. Like I know there's legislation passed that says Congress can't be held to insider trading laws. Mm-hmm. So that to me seems like maybe they don't have the authority to pass that legislation. And if they don't, then all of them cashing in on this insider trading knowledge would be illegal.
I would agree, just from a philosophical standpoint. But
Yeah,
no, I would also agree from the standpoint of if that's the construction of it, then yeah, they can't give themselves broader powers. Like you cannot legislate yourself into having broader powers,
that's
right?
true. That's absolutely true. I was actually just talking about financial gain, but you're right about
Okay.
that too. One
Okay.
thing I love to bring up is if you look, oh shoot, I'm losing my train of thought. Hold on, maybe I can get it back. Oh yeah, one of our founding fathers. Let me see. I can't remember which one, but I remember one of them saying, "Oh yeah, it's like democracies always fail as a consequence of the something like the legislative body legislating itself largesse out of the public treasury." So you look up largesse, and it just means like gifts. So
Yeah.
like literally the quote is all democracies have in the past, historically speaking, have failed as a consequence of it was as a consequence of loose fiscal policy. Once the legislative body like found out it could legislate itself largesse out of the public treasury. So I just see the state of things and like how much they make. Like think about this, right? How much did each one of them cash in on their public official salaries, and none of them even met because of COVID.
Yeah.
And yet, how many of you people maybe like had to go to work and had to do extra work, or maybe got laid off and couldn't go to work? And what did you get? Do you see what I mean? Like,
Yeah.
no
No,
wonder
and on top
democracies fail.
and on top of that, there's also other added elements there, which I don't think were ever contemplated in the beginning. And so, I mean, maybe they don't fall under the guise of kind of the formation of law in this country, but the idea that like a public official can campaign and create essentially a war chest and then be gifted the war chest at the end of their career is also something that seems like just inherently a gigantic conflict of interest.
That's crazy. I don't even know I'm not even that familiar. I don't follow political processes as much. Like our organization explicitly, we're a 501c. Well, we're applying for 501c3 status and not 501c4.
Yep.
And the difference there is that we can affect, the executive and judicial branches, but we're not here to try to change any legislative policy or anything like that.
Sure.
But great. Yeah.
Yeah. All right, last one. Any enterprise undertaken.
All right, so this one is actually one of my favorites. So yeah, any enterprise undertaken which tends to weaken public confidence and undermine the sense of security for individual rights is against public policy.
So we're talking what, fear tactics on the part?
What?
Are you saying like fear tactics on the part of legislators, or?
No, I'm saying like vaccine passports. Like I'm like literally like any enterprise undertaking that undermines public confidence and weakens public confidence and undermines the sense of security for individual rights. Like all of that.
Yeah. So what's funny is, or not what's funny, what's fantastic is it includes the phrase individual rights. Because if you take, we have a lot of collectivists right now that are kind of rowing the boat in the direction that it's going in. And their interpretation, or maybe they don't even stop to think, but their perspective is that their duty is to help the security of the collective, right? Like help the group security. But so what this is essentially saying is that any enterprise or kind of like project undertaken which undermines the security for an individual, right, is essentially
against public policy.
Yeah.
Yep.
That's like that in a nutshell. In a nutshell, is the argument against collectivism.
Yeah, totally. I see what you're saying. So you're saying there's become an issue, or there's a new issue arose, and it's the question of whether or not a group, based on their collective security or collective safety, could intervene on the rights of an individual. And this would show you, at least in terms of the administrative law of the body politic, the United States of America or Montana, or are you in New Jersey, I think, right?
Correct.
According to the administrative law of those bodies politic, yes, you could, I think. I'm not sure if I actually phrased that right, but I hope you were able to see what I meant by putting that.
No, that's okay. So yeah, we ran like an hour and a half, and that's fantastic because there was just so much there. I'm also going to have a lot to chop up too, so I can like make like little segments, and then each one of those bullet points or sections is going to become subsequent episodes. So I think that's absolutely fantastic.
Not necessarily every single one, but
yes, yeah.
There's going to be quite a lot of in-depth discussion on all sorts of aspects relating to these topics and more. This is maybe about 20 to 30%. Maybe this is about 20% of what we've got that we're currently looking into right now.
Awesome. I love that. We got a lot to work with. Trumping Consensus was watching and said, "Excellent talk, gentlemen," which is fantastic.
Awesome.
So,
do you have any questions, or does anyone have any questions? Because I know that it's, if you don't want to stay long, I don't mean to make your show longer.
No, that's okay. We'll shut it down for now. I always tell everyone, like, if you want to comment and things like that after the live is done, we'll definitely at least answer them, if not bring them on to the next episode. So yeah, people can comment and question. But yeah, no, this was fantastic. So we're going to be here again next week and try and make this a regular thing on Thursday night, if that works out. If not, we can play with schedules, but, we're going to try and make it a Thursday night thing. So yeah, no, Josiah, appreciate it. Thank you very much for your time. I'm going to play the outro here, hang out for a minute, we'll chat, and then we'll shut it down for the evening.
I just wanted to say thank you so much. You just don't understand how grateful I am for the opportunity. It's really a complex topic. It's hard to talk to people about, and having a platform like this, it's just something amazing, and I really appreciate it. Thank you so much.
I can tell you it's completely out of self-interest. I want to learn the stuff.
Well, that's apparently how it's all supposed to work.
Awesome. All right. Well, thank you, everyone. We will see you next week.
All right, have a good